Welcome, Beresford booth fans. I'm Andrew McKenzie, one of the partners here, and I've been handling real estate transactions and litigation for over 18 years, including in Washington State and California. Today, I will be discussing how you can go about getting access to property that is landlocked. More specifically, I'll be talking about one of the coolest tools available in Washington to compel access when all else fails, sometimes known as private condemnation. But before we delve in, don't forget to subscribe to our YouTube channel, where you can find highly valuable information on tons of legal topics, from family law to real estate, business, litigation, estate planning, and probate. Our firm has helped individuals and small businesses achieve their goals since 1946. Remember, this video does not constitute legal advice. Your specific situation will require consultation with a lawyer who can analyze your individual circumstances. Now let's dive in. First, what is landlocked property? Perhaps not everyone agrees on what that means, but for our purposes, property is generally landlocked if it does not touch a public right-of-way or cannot be feasibly accessed from a public right-of-way. 2, it has no deeded easements from a public right-of-way. And 3, it has no easements under any theory, such as an implied or prescriptive easement for access and or utilities. Importantly, even if property has access on paper or in a nominal sense, it may still be considered landlocked if you effectively can't use it without trespassing on someone else's property. If the property is landlocked, you may be thinking, what's the point of even owning it? It could even be a net negative to own property that you can't use because you're still stuck paying property taxes. But landlocked property can still be valuable in a number of circumstances, such as it could be used as a green belt or for environmental mitigation with a conservation easement or restrictive covenant entered into with a local jurisdiction. This could make a lot of sense where the property may be unbuildable anyway for environmental reasons. It might be sold to a neighboring landowner whose property isn't landlocked. Or it might have the greatest value based upon its potential for future use. In many cases, the owner of landlocked property will get the most value if they can find a way to develop the property and solve the access problem. If you believe you likely have or may be acquiring landlocked property, there are 3 basic avenues for solving the problem. These include confirming whether you really are landlocked, attempting to negotiate, and finally, seeking to compel access through private condemnation. First, you should determine whether it truly is landlocked. Sometimes access rights are buried in an old deed that can't easily be retrieved online. A good starting point is to ask a title company for a title report to see what easements they have discovered which affect the property. But it is common for there to be an easement right which is not found in any deed. This category of off-record easement can be what is known as a prescriptive easement, or in some cases, an implied easement. For more general information about easements and how to determine whether property might be burdened by an easement, you can view my other webinar on our channel called Does Your Property Have an Easement on It? How to Find Out. We'll place a link to that video in the description for this video. The second avenue for getting access to landlocked property is negotiation. Consider whether access might be feasible over any surrounding properties, and then try to negotiate with the surrounding owners for easement rights. In some cases, it may be possible to negotiate for a boundary adjustment that causes the landlocked property to abut a public right-of-way. In other cases, the landlocked owner may purchase the surrounding property which has access and then grant easement rights over the newly acquired property. Sometimes the surrounding owner's concerns are not just about money. They may worry about privacy or noise, or they don't want to see the landlocked property developed in a way that they think would negatively impact them. Therefore, you should consider non-monetary incentives to a neighboring owner in exchange for easement rights. A non-exhaustive list of examples could include agreeing to a buffer between any new development and the neighbor's property, or if the landlocked property would be subdivided, giving rights to a future parcel to that neighbor, or reciprocal easement rights, like granting some easement to the neighbor for parking, landscaping, hunting, or other needs, or agreeing to pave a shared driveway, thereby enhancing the neighbor's property value and usability, or agreeing to other restrictive covenants, such as height restrictions to preserve views, density restrictions, etc. The point is that money is often not the only concern, and that we can get very creative in persuading the neighbor that this can be a win-win scenario. But what can you do when negotiation is not an option or the neighbor decides not to be reasonable? Sometimes a neighbor will get greedy to the point that development of the landlocked parcel is rendered infeasible because of the demanded price for the easement. Take a hypothetical scenario. A landlocked parcel is worth $100,000 as is, but would be worth $1 million as developable property if it would have legal access. If the neighbor demands $900,000 in exchange for access, then the demand renders it economically infeasible to develop. As a rational actor, the neighbor might lower the price just enough to incentivize the landlocked owner to pay for access, but keep the price as high as possible to maximize the profit for the neighbor granting access. This is arguably a kind of extortion, even if it is legal, strictly speaking. Allowing this kind of barrier to land development would not only be unfair, but wasteful, as it would prevent privately owned land from being put to its most productive use. These concerns are why the drafters of the Washington State Constitution decided to enshrine in our Constitution the ability to compel access to landlocked property. Under the state constitution, the government is prohibited from taking private property for private use, but private property owners may take a private way of necessity from a neighbor. Private ways of necessity include easements for access and for utilities. Under the authority of the Washington Constitution, the Washington legislature has, for well over a century, provided a statutory scheme for compelling private ways of necessity, sometimes also referred to as private condemnation. Under the relevant statute, an owner or one entitled to the beneficial use of land which is so situate with respect to the land of another that it is necessary for its proper use and enjoyment to have and maintain a private way of necessity, or to construct and maintain any drain, etc., over or through the land of such other for agricultural, domestic, or sanitary purposes, may condemn and take lands of such other sufficient in area for the construction and maintenance of such private way of necessity. That is legalese for saying you can compel access over your neighbor's property if your property is landlocked. But what is necessity? Is every possible use of property a necessary one? Must necessity be absolute? What if alternative access is theoretically possible, but at a disproportionately higher cost? Courts have addressed these kinds of questions and arrived at the general conclusion that the party requesting private condemnation establish reasonable necessity, not absolute or strict necessity. The fact that some portion of the property is accessible via another route, or that access elsewhere could be possible for an exorbitant sum, will not prevent the landlocked owner from establishing reasonable necessity. However, just because the landlocked owner would prefer a particular easement route does not mean that the court will automatically grant it. Courts have held that under some circumstances, a party cannot obtain a private way of necessity if they created the necessity themselves, but merely purchasing a property you know is landlocked is not considered creating the necessity. The necessity already existed before the purchase. Generally, a party may be considered to have created the necessity if they took some affirmative action to cut off their own access voluntarily. It may be possible for a defendant to argue that there is no reasonable necessity if the defendant can show that Even with legal access, the property could not be put to reasonable productive use. This can be the case where environmental restrictions, steep slopes, or other practicalities make reasonable use impossible. Zoning for the landlocked property will also likely influence whether the contemplated use constitutes the proper use and enjoyment of the property. The defendants are free to present alternative routes, which typically will cross over the property of third parties. Washington law allows either the plaintiff or the defendant in a private condemnation action to bring in those third parties in as new defendants. When that happens, the newly added defendant must now defend against any attempt to impose a private way of necessity on their property. Sometimes this can result in all parties battling it out amongst themselves concerning whether there is reasonable necessity and which route makes the most sense. Once reasonable necessity is established, it will be up to the court to choose among the alternative routes available. The court is required by statute to give preference to routes that pass over non-agricultural land, and if agricultural land cannot be avoided, then the court should choose the land which is least agriculturally productive. Finally, the court must weigh the relative benefits and burdens of the various possible routes and establish an equitable balance between the benefits to the land for which the private way of necessity is sought and the burdens to the land over which the private way of necessity is to run. Once the court has determined that a private way of necessity over a particular route is appropriate, the court or jury must next determine how much compensation is due to the party whose property rights were taken. The general concept is to not put the party in a worse position than they had been able if they had been able to keep their property rights. Generally, this is measured from an objective valuation of the rights taken rather than the subjective aversion the defendant may have to their new neighbor or the neighboring development. The amount by which the plaintiff's property value increases should be irrelevant to the determination of how much compensation is owed to the defendant. It is good practice for both parties to present competent evidence, ideally through a professional appraiser, of the value of the property rights lost. Bear in mind that typically the value of the non-exclusive easement will be significantly less than the value of outright title to the property affected by the private way of necessity. One of the most bizarre aspects of Washington's private condemnation law is that it is possible to lose and still be awarded your attorney's fees. I'm not aware of another area of the law that is so generous to losers. This is a major consideration which a plaintiff in a private condemnation action should take into account before making a decision to sue. The question becomes, however, whether this gives defendants carte blanche, that's basically French for a blank check, to run up attorney's fees and stubbornly resist the private condemnation only on grounds of personal preference or animosity. The statute opening the door to an award of attorney's fees to a losing defendant does not make the award mandatory. It lies within the trial court's discretion. There is not a lot of case law in Washington fleshing out exactly when attorney's fees are or are not appropriate, but I'll give my opinion that generally speaking, if a losing defendant whose property just got privately condemned wants to get an award of attorney's fees, they better be in a position to show the court how they made a good faith argument, either about reasonable necessity or about alternative routes that should have been preferred. If they can't make that reasonable argument, then there's a good chance that they were just defending that action frivolously or just on grounds of personal principle and not any ground rooted in the law. Here's an illustration of a private condemnation dispute in the recently published Washington decision of Nayeri versus Eagle Hardware and Garden. And there, the plaintiffs purchased two surplus parcels shown here in the picture. That's these two parcels outlined in red along State Route 16 in Tacoma from the Washington State Department of Transportation. That's the DOT. After DOT determined the parcels were no longer needed for a planned freeway project. Plaintiffs apparently obtained the parcels at a significant discount, knowing that they were landlocked and that the department would not grant any access from State Route 16. Plaintiffs hoped to develop the property with a 10,000 square foot office building After attempting unsuccessfully to negotiate for access over several adjacent privately owned parcels owned by 3 defendants, plaintiffs filed a lawsuit to compel access via private condemnation. The defendants asked the trial court to determine, without a trial, that plaintiffs were not entitled to private condemnation for several reasons. One, the plaintiffs knew the property was landlocked when they bought it, and such was reflected in the discounted purchase price. Two, it would supposedly be legally impossible for plaintiffs to ever develop the property given steep slopes, regulatory difficulties with the city of Tacoma, and lack of any concrete development plans by the plaintiffs. And three, the defendants each showed reasons why access over their property would impose, supposedly, undue burdens on them. The trial court granted judgment to the defendants without a trial, primarily on the ground that the plaintiffs did not have or had not pursued any permits from the city of Tacoma for any concrete development plans. But the Court of Appeals reversed that judgment, making several significant rulings. First, the Court of Appeals rejected the defendant's argument that plaintiffs' knowledge of the landlocked status of the property precluded a claim of private condemnation. And the Court of Appeals said the following: holding that buying property known to be landlocked means the purchaser can never demonstrate reasonable necessity under the statute would contravene Washington's overriding public policy goal against making landlocked property useless. The court distinguished these circumstances from another case from Washington in which a landowner was barred from seeking private condemnation where they had voluntarily locked their own property and waited several decades before bringing suit. In the Nyeri case, that's the one we're talking about right now, the court noted that the plaintiff's knowledge of the property being landlocked was a factor which the trial court could consider in determining whether there was reasonable necessity for private condemnation, but it may not be the sole ground for denying relief. Second, the Court of Appeals rejected the defendant's claims that it was legally impossible for plaintiffs to build on their property. Plaintiffs' experts testified of their opinion that the property could be developed in compliance with city regulations and that engineering infrastructure and methods could solve any geotechnical or environmental concerns. The opinions of the defendant's experts, to the contrary, did not justify granting judgment without a trial. The Court of Appeals contrasted these facts with another case from 2000, wherein development was truly legally impossible because the parcel in question was surrounded by state land, which could not be condemned through private condemnation. Third, the Court of Appeals held that the plaintiffs were not required to have a concrete development plan for the property in place to determine reasonable necessity for private condemnation. And the court said it is true that plaintiffs' lack of concrete development plans leaves significant questions about the scope of the easement that a trier of fact could grant. But the scope of access is different from the necessity of access. Fourth, the Court of Appeals rejected arguments from the defendants that imposing an easement on their property would cause an undue burden due to destruction of parking stalls, rendering site security difficult, or interference with business operations. And the court said, expert testimony that a route is the only reasonable means of accessing a property is sufficient to create a genuine issue of material fact regarding feasibility and reasonable necessity that precludes summary judgment. Finally, the Court of Appeals affirmed the trial court's grant of attorney's fees against the plaintiffs, even though the court reversed summary judgment. This is in large part because that statute, the private condemnation statute that allows the court to award attorney's fees to the party resisting condemnation, makes no distinguishing, it does not distinguish between whether or not the easement is actually granted or not. So it was within the trial court's discretion to still grant attorney's fees. So in conclusion, if you own or you are considering purchasing landlocked property, or if you have a neighbor seeking to obtain access over your land, we would love to assist you. Give us a call at 425-776-4100 or shoot me an email at andrewm@beresfordlaw.com. And thanks for watching.